May it please the court. My name is Keith Fuicelli, and I am privileged to appear before this panel on behalf of Bruce Bailey. The heart of this appeal really lies with getting the benefit of what you pay for. It's really about getting the benefit of your bargain. And in this case, the bargain is this. You purchase underinsured motorist coverage for a promise. And the promise is, if X happens, we will pay Y. And with 10-4-609 amendments in 2008 that I'll touch on in a moment, the language of that amendment, something this court has called plain and unambiguous, is if you are injured and your damages exceed the amount of legal liability coverage, then we will pay. In this case, Mr. Bailey's damages were $300,000. There was $100,000 in liability coverage, and therefore, under 10-4-609, State Farm is required to pay. That's the benefit of the bargain that Mr. Bailey received. When he paid money for this promise, the money was, if I'm injured and my damages exceed the amount of legal liability coverage, then you pay. And it doesn't matter if the tortfeasor hits the lottery and pays, and it doesn't matter if some corporation decides for its own reason to pay. The benefit of the bargain that was paid for under the plain and unambiguous language of 10-4-609 is, if X happens, then we will pay under Y. And that's exactly what occurred in this case.
Mr. Fuicelli, how is your argument consistent with cases that have held that the purpose of underinsured motorist insurance is to make sure that a driver who's in an accident who's not at fault doesn't suffer financially because the other driver was uninsured or underinsured?
So this position is entirely consistent with that. Obviously, there is a long line of cases from this court that talk about the purpose of underinsured motorist coverage being to place someone in an advantage or in the position they were in if there were not enough insurance coverage to cover the losses. But just because there's a long line of cases that back up that just proposition does not negate from the equally just proposition, which is you get the benefit of your bargain. It was interesting, I was talking...
The benefit of the bargain here would have actually left him holding the bag for $100,000 because there was $100,000 in coverage, $100,000 in UM, and $300,000 in damages. But as a result of the promise and to what amounts to increase the coverage of the tortfeasor, your client ends up getting made whole, something that in the absence of that promise you would not have got. Once that promise is made to the tortfeasor, how is he still underinsured?
He's underinsured under the plain language of 10-4-609 as amended in 2008, because the plain language of the statute says this coverage shall cover the difference between legal liability coverage and your damages. And one of two people in this case is getting a windfall, I will concede. It is either State Farm Insurance Company that gets a windfall in the form of insurance premiums that were for nothing, or Mr. Bailey gets a windfall in the form of the benefit of the promise that State Farm agreed to enter into when it took his insurance premiums. And I would direct the court's attention to the language contained in Tubbs v. Farmers Insurance Exchange. Regardless of what amount, if any, and this is a quote, Your Honors, regardless of what amount, if any, the insured receives from the liable party, the UIM insurer is required to pay for damage in excess of the tortfeasor's legal liability limit. And this sentence, I believe, hits the nail on the head. This is precisely the coverage that the UIM insurer agreed to provide in exchange for a premium. And that's on page 927 of that opinion. The opinion goes on to state, it is irrelevant whether and in what amount the insured recovers from the underinsured motorist. It is irrelevant because
Right, because the way that they amended the statute in 2008, it explicitly said that there is no set-off for what is recovered from the tortfeasor. So if you were able to recover the $200,000 from, you had the $100,000 in policy limits, and you were able to recover the extra $200,000 from the tortfeasor, that does not relieve the UM carrier from liability, but you didn't recover it from the tortfeasor. You recovered it from his insurance company. Doesn't that matter?
I don't believe that it does matter, Your Honor. And in some respects, if there were two different insurance companies, it may make the analysis a little clearer in my mind. If State Farm insured tortfeasor Hoover, but Mr. Bailey was insured by American Family, just because State Farm makes a gratuitous offer to pay for its own reasons, then American Family gets a windfall under those circumstances. So our position is that under the clear, plain language of 104609, State Farm's gratuitous offer to pay is not legal liability insurance. And because it is not legal liability insurance, Mr. Bailey is entitled to collect under the underinsured motorist policy. And even if the court disagrees with me in that respect, probably more critically important here is the waiver issue. And what occurred in this case, and I hate to say it because it may sound like I'm whining, but what occurred at trial was not fair. We spent half of our time at trial arguing about an issue that if State Farm is right and this underinsured motorist policy isn't at play, is totally and completely legally irrelevant. Half of the time at trial was spent rebutting affirmative defenses for the underinsured motorist policy at issue here. And all of the parties in this case proceeded to trial under the trial management order, under the assumption that if Mr. Bailey's damages exceeded $100,000, State Farm would pay. Fortunately, sometimes the law provides a remedy to address inequities and address things like fairness. And in here, the remedy comes from the Dinosaur Park v. Tello opinion and State ex rel Ruthers v. Johnson Law Group, where a defense is not asserted in defendant's responsive pleadings or intentionally or actually tried, the defense is waived. And going back to Judge Welling, your point earlier about the fact that this is State Farm, it's actually critically important here that it's the same insurance company. State Farm made the strategic decision a week before trial to send a letter saying, we'll pay whatever the verdict was. State Farm then had an obligation under Rule 15 to amend its answer so that this issue could have been raised pre-trial. Instead, Mr. Bailey suffered great prejudice with the character assassination that occurred related to issues that were completely and legally irrelevant to the underlying claim. And I note the language from Ruthers v. Johnson Law Group, where a division of this court said to hold otherwise. In other words, to allow a defendant to amend its answer post-trial, which is exactly what is occurring here, would allow defendant to avoid the consequences of their failure to plead the defense.
Well, I'm just not quite sure how I understand how you convert what really was a motion for judgment. And appreciating the frustration of trial being consumed by things that subsequently were not pertinent at all. But how do you convert that into a defense? Why should we not simply regard it for what it was? A request that the judge figure out where the judgment should lie.
Well, that's a great question, Your Honor, and it goes to what the definition, what an affirmative defense is or is not. And we cited in our brief that an affirmative defense is, even if all of the allegations contained in the complaint are true, the affirmative defense defeats coverage. And here, the allegations in the complaint and the trial management order were, if our damages exceed $100,000, this policy at issue comes into play. So it is our position that it was an affirmative defense and that State Farm had a duty to amend its answer under Rule 15. Otherwise, we suffered great and severe prejudice by what I hesitate to call as gamesmanship by State Farm. They knew very well what they were doing. They knew they were going to come into court and commit character assassination of Mr. Bailey on an issue that was totally irrelevant to the underlying tortfeasor's claim. And they got the benefit of that. And it's our position they had an obligation under both the Tello case and Johnson Law Group to amend their answer pursuant to Rule 15. And with that said, I'd like to reserve the remainder of my time for rebuttal.
Very good, thank you. 4 minutes and 25 seconds.
Thank you, Your Honors. One point that I thought was interesting is that we were actually put on the clock at trial here because we were under such tight time constraints. And the issue that Mr. Chambers raised about 2 defense attorneys is exactly the point. We were at trial being put on the clock, dealing with not one, but 2 different defense attorneys. So every witness is being cross-examined by 2 different defense attorneys, and it really did extend the point of the trial or the time of the trial considerably. To Judge Talbaum's question regarding why did State Farm give this comfort letter, the reason they did that is because there were prior policy limits demands made. And if they didn't do that, then their tort fees, their insured would have a claim against them for bad faith under the Basher line of cases. So it is a self-interest on State Farm's part to do that when they have turned down prior policy limit cases, demands. Mr. Chambers said that he's not aware of any case law or statute that would sort of dictate the outcome in this case. And I'd like to read a passage from Jordan v. Safeco, which I would submit to this court is outcome determinative of the issues before this court. Before the 2008 amendments to that section of 104609, the statute required UIM coverage for damages in excess of amounts paid pursuant to a tortfeasor's liability policy. As amended, however, 104609 requires coverage for amounts in excess of a tortfeasor's liability policy. The amended statutory language is plain and unambiguous. The insurer's obligation to pay benefits is now triggered by exhaustion of the tortfeasor's limits of legal liability coverage, not necessarily any payment from or judgment against the tortfeasor. And that's at page 449 of that opinion. The comfort letter, we haven't spent much time on it, but the comfort letter cannot be legal liability insurance.
Why not?
Because the statute 104609 cites to Title 42 and provides the requirements of what legal liability insurance is, one of which requires a certification with the state that never occurred here. So for those reasons, it is our position that it is not legal liability insurance and is no different than if the tortfeasor won the lottery or had a rich uncle or somebody decided to pay this verdict. It is nothing more than a gratuitous offer to pay by an insurer for its own benefits and is not legal liability insurance. And even if it were, the waiver arguments in this case, we hope, are compelling. Because first of all, I would strenuously disagree that even if this would not have been an issue, State Farm would have been able to attack Mr. Bailey's credibility based upon representations made in an effort to settle his claim pre-suit under Rule of Evidence 408, right? But the point of the matter is, Mr. Bailey was severely prejudiced by all of this information that came in. It was clearly a strategic decision on State Farm's part, as admitted. They liked the idea of having 2 lawyers. They liked the idea of coming in and addressing head-on these affirmative defenses that now are legally irrelevant. And for those reasons, Your Honor, we would ask that this court reverse the Court of Appeal, unless the court has...
I have one more question.
Yes, sir.
Typically, there would be a subrogation right for the UM carrier to recover against the tortfeasor if it
Yes.
had to pay.
Correct.
But because of the way that this is structured and the windfall that is being sought, that vanishes, right?
I'm not sure I suppose there would be no reason why State Farm, if they pay on the $100,000 policy here, could not go after Mr. Hoover personally for that $100,000. There was no release signed. There was nothing extinguishing State Farm's right to do that. They have every ability to do that if they want. Now, they'll probably get sued by Mr. Hoover for doing that, but they can do that if they want.
Even though the judgment's been paid in full and then some.
Yes, nothing would prevent them, if they pay the $100,000 on the underinsured motorist claim, that judgment would not extinguish State Farm's right to go after Mr. Hoover personally for those monies.
Okay, thank you.
Thank you, Your Honors.